Welcome to my channel. I'm Advocate Manjit. In today's video, we'll discuss about what exactly is a will and how exactly it's made. Now, before we go on to that, let's start with some basics. So, a property of a deceased person would devolve after his death according to a will which he or she may have made during his or her lifetime. But in case if there is no will made by that person, then the property will devolve according to intestate succession. Now, what exactly is intestate succession and how do you go about that? We'll discuss that in our upcoming videos, but for today, let's focus on what is a will and how exactly you can go about making a will. Now, the provisions regarding to what a will is and the execution of a will is in the Indian Succession Act of 1925, and this act applies to people belonging to all faith, religion except Muslims. And also you have to be mindful that there are certain sections in this act which categorically mentions that that particular section wouldn't apply to particular faiths or religions. You'll have to be very careful when you're reading this act. At the same time, what is a will? So basically, a person can make a will during his or her lifetime or whatever he desires of as to after his death who should get his property. Now, property would involve both movable as well as immovable property, whatever he has and whatever his desires are to whom the property should go to. Now, before I get into how exactly you can go about making a will, first things first, let's get used to some terminologies that I would be using in this video. The first is testator. Now, who is a testator? A testator is the person who is making the will. Then, beneficiary or a legatee. Beneficiary or the legatee is the one who is getting something or is benefiting something from the will, is called a beneficiary or a legatee. The common term that is used is a beneficiary. And the third terminology is codicil. Codicil is nothing but a supplementary will. So if I've made a will and there are certain additions or modification, alteration that I have to make to the original will, then I can probably make a codicil, which is a supplementary to the original will, and it has to be read along with the original will. That is what a codicil is. So wills are broadly classified into privileged and unprivileged wills. So what are privileged wills? A will which is made by a person belonging to the armed forces, be it a soldier, an airman or a mariner, when he is involved in a warfare. Mind you that not at all times, but when he is involved, when he is at the war zone, at that time the person can make a privileged will, provided he is above the age of 18 years. And this is governed by section 65 of the Indian Succession Act of 1925, where it clearly states that this section does not apply to Hindus, Buddhists, Sikh and Jains. So you have to be mindful of that this section would not apply to people belonging to these faiths. Now, coming to what is an unprivileged will then. So any will which is not privileged would be an unprivileged will. Now, unprivileged will can be holographic, so wherein the testator would make the will in his own handwriting, that's an holographic will. It can be InOffice will. So usually when you make a will, the testator would give away his property to somebody he knows, somebody from the family, somebody he has love and affection for. That's how usually people give away their property in a will. But if the person, the testator, is giving away his property to somebody who is a stranger, who is not a family, then it would be an InOffice will. Now, if I have to give you an example of what could constitute an InOffice will, now, for example, if there is an old man, there is a nurse or probably a doctor taking care of that person during his sickness, then if he bequeaths that property, his property to that nurse or doctor who is stranger, who is not family, to the testator, then that would be termed as an in-office will. Thirdly, it could be mutual or reciprocal will, wherein A is bequeathing his property to B, and in return B is bequeathing his property to A. That's reciprocal will. And it could also be joint will, wherein two or more testators jointly make a will, a combined will of two or more testators. Now coming to who can make a will. So any person who is of sound mind and is 18 plus, or if he or she is not a minor. Now, according to the Indian Majority Act of 1875, any person below the age of 18 years is a minor, so that person also cannot make a will.